Mr. Katyal, whether Arizona stands alone or not doesn't have much to do with the question that we have to decide, but why would we expect other states to file in a case that involves the kind of stuff that you've been talking about, the interpretation of one particular state procedural rule?
Well, because my friend on the other side says if you do this, it's going to open federal court review to other states and things like that. And our only point here is to just simply say, no other state's worried about it, because I think this is a really unique fact pattern. There are 27 states that have the death penalty, nothing about that. 16 states have parole eligibility.
If it's a really unique fact pattern, then I don't know why it matters whether other states are here or not. To get back to the question I was trying to address in my prior question, suppose Arizona says, or any state says, that we will limit this form of collateral review to situations in which we, in our judgment, believe that there has been a significant change in the law, including federal law. So it's solely their judgment as to whether there's been a significant change or not. Is there anything wrong with that?
I think there could be under this court's precedents in Danforth and Yates. We don't think you have to get there, but I think those cases do set forth a minimum amount, a minimum floor of retroactivity. And if the state post-conviction review proceeding isn't open to them, to certain federal claims, then I think it could present a problem under this court's decisions.
So this is your argument about independence?
It's an argument. I think it would probably be more about adequacy, Justice Alito, that basically the state is not offering an adequate ground because that forum is only open to certain claims. Now, again, our point is you don't need to have post-conviction review. But if you do so, it's got to be even-handed. It's got to be done in advance with notice for a defendant. Someone like Cruz did everything right, making his objection at the trial, making it at sentencing, making it after sentencing on direct review, filing his post-conviction review proceeding soon after this court's decision in Lynch. And yet they turn on a dime and say, oh, no, now there's a new interpretation of 32.1. And I think you should, if you might, ask my friend on the other side, name one precedent ever when the Arizona Supreme Court, indeed any court in Arizona, said 31.2G is not met when precedent has been overturned. They can't point to a single example. We point to many the other way, including most predominantly the Rendon decision. And so,
Mr. Katyal, before your regular time is up, why isn't the situation that I posited the same as the situation in Stewart versus Smith?
I'm so sorry, Justice Alito. I'm not familiar with Stewart versus Smith.
Okay.
I don't think that was briefed in this case.